Reality. The events and evidence I'm about to reveal are disturbing, and they show the reality many pro se litigants face. The legal system is unfair and it mistreats the self-represented. This known mistreatment is not an accident. The most cited legal scholar, Judge Richard Posner, stated people without lawyers are mistreated by the legal system. I, along with many of you, have found this to be true. There are two major components of the legal system: lawyers and judges. This video is about lawyers. For the record, I want to state that the events presented, in my opinion, can only be construed as willful bad faith or gross incompetence. Either way, I believe that that lawyer lacks the ethics or the skills to practice law. This post deals with a lawyer. If a lawyer tells a lie in front of the judge in order to make a pro se look bad, can he be reprimanded? If the rules are followed, yeah, but we're pro ses. We don't get the benefit of the rules. But we'll get to that later after the facts of this case. The facts: pro se plaintiff and attorney represented defendant. They exchanged their discovery. The defendant's discovery seems questionable. The pro se provides the defense with a long and detailed list of discovery disputes to discuss. The defense never provided a discovery dispute list. This is important because the pro se asked via email 6 different times and in a phone conversation. Listen to the 2 instances the pro se requested that list. When do you anticipate having your comprehensive list from the discovery that I've given you?
I don't know.
You could possibly have your request for whether further information or clarification or whatever by Thursday. So that's what you're thinking?
Yes.
Okay. Though the defense counsel had agreed to provide the list, they never did, and subsequently made a court filing stating the plaintiff refused to identify documents. This implies the plaintiff was uncooperative when asked. Plaintiff made a corresponding filing. They list the dates that they requested the discovery dispute list. During the meeting with the judge, defense counsel continued the deceit and acted as if they had provided plaintiff with the list or asked for any additional discovery information. In that same meeting, the plaintiff responded by notifying the judge that there were 7 different requests. An exasperated plaintiff further revealed the production of 769 pages and advised the judge that it felt like defense counsel withheld the list in order to bash the pro se and paint the plaintiff as uncooperative. So those are the facts of this particular case. This attorney either forgot, which is highly unlikely, or ignored the request for the purpose of presenting this deceptive narrative. The defense counsel made this false claim not only in a court filing in writing, but also to the judge during a meeting. So what rules were violated? American Bar Association Rule 8.4C, misconduct. It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, and misrepresentation. Well, he certainly engaged in deceit and misrepresentation. So what else? What other rules? Federal Rules of Civil Procedure 11B, 1 and 3. It states that signed papers filed with the court are representations to the court, and they are factual and they're not being presented for any improper purpose, as in to incite anti-pro se bias. So that's a false statement in a filing which violated Rule 11. We also have ABA Rule 8.4, which is misconduct. It is professional misconduct for a lawyer to D, engage in conduct that is prejudicial to the administration of justice, meaning to engage in an action or behavior that could unfairly influence or undermine the legal process, like using deceit. Bar Rule 3.4, D, fairness to the opposing party. A lawyer shall not, in a pre-trial procedure, make a frivolous discovery request. Here, frivolous refers to a bad faith request intended to harass, delay, or embarrass the opposition. That refusal to cooperate assertion was in bad faith. It also served the purpose of inciting anti-pro se bias in a system that is known to mistreat the self-represented. Rule 3.3, duty of candor, A1. A lawyer shall not knowingly make a false statement of fact or law to a tribunal. Tribunal is the court or the judge. And finally, Rule 3.3A3. A lawyer shall not knowingly offer evidence that the lawyer knows to be false. Here, the lawyer is an officer of the court and he uses that trusted position to deceitfully offer false and negative character evidence. We pro ses know that the legal system is unfair. Lawyers know it too. Some will use that to their advantage for a cheap win. As a pro se litigant, know that your words often mean nothing to a biased judge. Legal documentation of the communications with these unethical lawyers, like emails and improperly obtained audio recordings, may help you with your sanctions motions or your bar complaints. Notice I said may because some biased judges really don't care.